Looks like everyone's ready. Our next case this morning for oral argument is Chicoine versus Wellmark. And it looks like the attorneys are ready. Mr. Norris.
May it please the court. I have worked and worked to get this thing whittled down, and I have way too long an argument no matter what else I do. So I'm going to go to what I think is the very essence, the whole concept that is misconstrued in the district court, and then work from there as long as you let me. The charge is a concerted action, a agreement or combination in restraint of trade or conspiracy to monopolize. Both are in that statute and in Iowa. Now, the concept of damages in the Sherman Act, Section 1, is over 100 years old and starts out with the Chattanooga Foundry case in 1906, which they determined that one way to determine damages is if indeed it's usually the depressed price. If indeed the depressed price is proven, then there's got to be a non-depressed price, and so you look either before or after to see what the non-depressed market was. And we're not talking about individual pricing or anything of that nature. We're talking about a market price. Sometimes it's an average. In this case, it's absolute fact. Now, you go then to Bigelow versus RKO Radio, 1946.
What is an absolute fact?
That we have an absolute measure of damages, that there is only one price being given to chiropractors. There's no multiple or any variation at all. And also, the market that we say is the unrigged market, the negotiated market, is the RVS market that's mandated to the Center of Medicaid and Medicare Services. And that one also is undifferentiated as far as wavering up and down between various different people, actors in the market. Now, Bigelow says, well, before and after doesn't often work. And so we're going to decide that we're going to look to a yardstick measure. And what we're going to do is we have this depressed price because of the price fix. And we're going to look to some other market that is related that has normal competition. And we're going to compare the depressed price to the non-rigged price, and the difference would be the measure of damages. Now, the essence of that whole idea is that the action is for the combination, the concerted action that is a restraint of trade, in this case a price fix. And it's not what individuals in it do, it's what the concert does. And likewise, the damages are concerted. You have to look to each individual defendant and seeing whether they were offering another price or not. The concept is what happened during the conspiracy.
You're talking damages, but the district court's ruling focused on a threshold or front-end issue of antitrust injury and concluded, and we're reviewing for abuse of discretion. The judge concluded that individual questions predominate because if you put the Wellmark price aside, are they going to be better off if Hy-Vee is competing with John Deere and all the others, if they're back into a competitive market? Does that devolve into a lot of mini trials?
There is such a thing as looking into what would be a better market. What you're looking for is there a competitive market? Chiropractors sell their services into a fixed market. And what the district court was talking about is that you have to prove that the particular self-funded co-conspirator had another price at another time. Well, most of them don't. If you have to prove each person who they dealt with, and did those self-fundeds have a market price or a competitive price for chiropractic before, or any other health care practitioner?
Why are rates paid to MDs and DOs the correct comparator here?
That gets back to the RBRBS system, which is a big negotiating tool in the CMS, where you have all sorts of representatives of the various different medical specialties. You have a chiropractor, you have a physical therapist, maybe a couple others, but most of that is just haggling back and forth to determine what the difference it would be to arbitrary one, what the difference would be between the various different services, the various different practitioners, all of them do. And in our case, we have a very definite comparison between chiropractors manipulation and osteopaths manipulation. And osteopaths get the 100%, and chiropractors get 90%.
Is this the theory that you're advocating for now, the one that the trial court concluded you were judicially estopped from arguing?
Don't know why that is, Your Honor. You look at the elements of the case for price fixing, and there is no such element for what would any particular person have done in a non-competitive market, or would they have been into it?
When you argue one theory, you run into the single actor defense, and then so you shift gears to argue, the problem in this case is that this arrangement took all these self-funded plans out of the competitive marketplace. So which horse are you riding?
I'm not talking about any horse. I'm talking about the fact that we sell into a competitive market, or should. All right, we sell into it. They have fixed the price so we get less, considerably less, than what the RBRBS says is the competitive price.
The operation of the Wellmark handling all these self-funded plans, then if Wellmark's the agent for then that's the single actor defense. And if you're arguing the other thing, it seems like you devolve into a lot of mini trials. So your reply brief doesn't talk about judicial estoppel. Why is that? Why did the district court err on that?
Different theory. We're talking about what are the elements of the case. Now, one thing you have to determine is something that's not normally considered an element of the case, an element of the case. Otherwise, it doesn't make any difference. It doesn't make any difference to the case what some self-funded did before. If you had a whole market that was that way.
Here a little bit, not at a high level, but on the ground. So your allegation is the administrative services agreement is unlawful. Is that right?
I'm saying that the agreement to take Wellmark's price and use Wellmark's network, which limits the price, the maximum price, because there's no balance billing allowed the practitioner. That is what we're talking about.
to? What agreement? The agreement between who?
The administrative services agreement, but there's several facets of that agreement. What we're complaining about is the agreement to price fix.
Your complaint is about the administrative services agreement, correct? And so if they didn't have an administrative services agreement, then what would happen under your theory of the case?
The Justice Waterman said in the first Mueller case, if it's just simply one entity, one company, they can do whatever they want to do. The issue is what happens when you have a conspiracy. That's when you look as to what the effect of the agreement was made within the AP.
I'm having a little trouble understanding your theory. So the administrative services agreement is unlawful, and they shouldn't have them.
In the administrative services agreement, which they get a separate price for. There's a price for the other administrative actions, and then there's a price for renting the so-called network market. And that is done at Wellmark's price. Wellmark sets the price. It's one price all year, and in the price lists Wellmark produce, and that is what the problem is you've got a combination, you've got several people, all of whom are in the business, incidentally, by either the choice to be a self-funded or a governmental choice. All of those people are in the market to pay for healthcare services.
But don't we have to look at the non-ASA world? So if we didn't have these ASAs, there would be competition, presumably, among all of the self-fundeds plus Wellmark. Don't we have to look at that world and trying to figure out whether there's commonality among members?
I do not think that is the way that the antitrust laws work at all. It isn't what would happen if you just disbanded the conspiracy. There is an assumption that they would have the market price, or in this case, some of those self-fundeds would just go out of the market to pay their employees medical services.
You said the term, your issue is not the ASA, it's the price in the ASA.
The agreement to price fix, agreement to take Wellmark's price, whatever Wellmark's price is, they're going to give to their employees, healthcare practitioners as payment too. And they have agreements, they have practitioner agreements with all these people, and included in that is a no balance billing thing, where so the maximum price that Wellmark pays is all that the practitioner gets. All right?
Get back to Judge Crane's order, and in particular, the issue that I want to talk about is the analysis of whether or not the class has been certified or should be certified. And she says that she's talking about the but-for world, and I'd like your comment on this. She says there's 466 self-funded employers in Iowa. Each class member has a different percentage of patients who are employed by different self-funded employers. 12.1% of the proposed class doesn't even have self-funded patients, and therefore no injury. How do you address that? This is one of her reasons for denying the request for class action.
But-for is a standard proximate cause. Did the injury, or did the action injure you? But for the action, would you be injured? And I say, but for the conspiracy, they would be injured in part at least. They might not be injured because Wellmark by itself could do anything it wanted to do. It's when Wellmark increased its market share from about 31% in 1985 to well over 40%, and even 70% of the PPO market. So Wellmark acquired a whole lot more members, patients were employees of all these self-fundeds. It's understandable that Wellmark did that because their original statutory purpose was just simply to give medical services themselves through their practitioners. But what happens then is you get these self-funded things going through, and you're going to lose a lot of business if you don't come up with some way to keep those self-fundeds, all right? But the fact is that in order to be self-funded, you have to agree that you're going to pay the prices, and that would put you in the same market as Wellmark. Wellmark pays.
Right here, you get to come back. So hold that thought, okay? All right, hold that thought. Mr. Holmstead.
May it please the court. As plaintiffs conceded, they cannot carry their class burden with respect to the only theory in their motion for class certification. That was the same theory that they have pursued throughout this litigation. The district court rightly held that the plaintiffs are judicially estopped from changing to a theory they disavowed in order to survive a motion to dismiss. It wouldn't make any sense to let plaintiffs change theories and restart the litigation, including reconsidering the motion to dismiss. No matter what theory plaintiffs try to pursue, they can't identify any error in the district court's ruling, let alone an abuse of discretion. There's no dispute that the overarching class test is to identify the elements of the plaintiff's claim and see whether they presented evidence capable of proving those elements for all class members. And the district court got the elements exactly right: liability, antitrust injury, and damages. With respect to antitrust injury, on page 35 of the reply brief, plaintiffs concede that fact of injury and whether the injury is of the type the antitrust laws were designed to prevent are two separate requirements they must prove. They've also conceded that if someone was uninjured by the challenged conduct, it's inappropriate to include them in the class. That's at Appendix Volume 1, 519, and Volume 2 at 2259. To show a fact of injury, plaintiffs must show that they would be better off but for the challenged conduct. They raised the Chattanooga case, in which the court said that you'd compare the actual world to, quote, natural conditions had the combination been out of the way. That's the but-for world. And if the plaintiffs aren't better off in the but-for world, they have no damages, no injury, no claim. Plaintiffs' unusual antitrust claim here makes class certification even more difficult for two reasons. First, they don't challenge a horizontal price fixing agreement among actual competitors already competing in the marketplace. Instead, they challenge 466 ordinary course agreements between Wellmark and its customers who are not competing in the marketplace. As this court held in Mueller, that's not horizontal. It's not price fixing in any antitrust sense. It's not a per se claim. It's only rule of reason. And alleging that hundreds of customers would become competitors creates huge issues for class because plaintiffs must have evidence that those customers are ready, willing, and able to enter the marketplace. Counsel represented that it's an absolute fact that there is one price and all chiropractors are paid exactly the same. As we explain in pages 29 to 31 of our brief, that's not the case. In fact, there's a 5,000 to 1,000% difference in the rate that each chiropractor is paid based on each chiropractor's individualized billing practices. The plaintiffs in this case also admitted that the reasonable value of each chiropractor's services varies from class member to class member, and Wellmark's existing prices could be reasonable for some class members. The second reason plaintiffs' claim makes class certification even more difficult is that the challenged agreements benefited many class members. I'll give just two examples. First, Wellmark offers a broad PPO that doesn't pay chiropractors less just because they recently graduated or live in a rural area. Any chiropractor that joins Wellmark's PPO gains instant access to hundreds of self-funded employers at competitive rates. In plaintiff's but-for world, that option is off the table, and many chiropractors would be worse off. Second, plaintiff alleged that Wellmark's HMO network, or ICPC or WHPI, is too narrow and excludes too many chiropractors. In plaintiff's but-for world, more chiropractors would join that network, but they would necessarily take patients away from the chiropractors who are already in that network. Shifting patients away from some class members would make them worse off in plaintiff's but-for world, which creates winners and losers in the class. Sorry.
The argument that we should use a yardstick measure, comparing it to DOs and MDs, Why do you say that that's wrong?
Thank you, Your Honor. Plaintiff's yardstick is a spreadsheet. It's an Excel file that plaintiff's counsel created. And it compares, so it first lists Wellmark's commercial rates for MDs and DOs, and then it lists Wellmark's commercial fee schedule for chiropractors and subtracts the two with a 10% haircut. So it shows 90% of Wellmark's commercial rates for MDs and DOs. That spreadsheet was before the district court, and it properly held that it's not capable of proving antitrust injury. A spreadsheet that shows the rates are different isn't evidence that anyone would actually get the higher rate in the but-for world or but for the challenge conduct. And the spreadsheet ignores how the actual world and any but-for world would work. There's no evidence that any chiropractor, let alone all of them, would be able to merit 90% of Wellmark's commercial rates for MDs and DOs in any but-for world. And in fact, 63.5% of the charges in plaintiff's yardstick spreadsheet were billed below the commercial MD and DO fee schedule, and the plaintiffs admitted that their billed charges reflect the reasonable value of their services. And calling this spreadsheet a Medicare yardstick doesn't transform it into something capable of proving injury to all class members. In fact, it's not a yardstick at all. The plaintiffs cite the Greenhaw case from the Fifth Circuit to illustrate what a yardstick is. There, the plaintiffs challenged an agreement to fix the price of liquor in Lubbock, Texas. And the plaintiff's expert opined that economic conditions in Lubbock and Dallas justified using the price in Dallas as, which was outside the conspiracy, as what the price would have been in Lubbock, but for the alleged conspiracy. So the yardstick was to compare the actual price in Dallas with the actual price in Lubbock. A Medicare yardstick here would be comparing Wellmark's actual prices to Medicare's actual prices. The problem for plaintiffs is that Medicare pays far less than Wellmark. For 75% of the CPT codes in plaintiff's yardstick spreadsheet, Medicare pays zero. It doesn't pay anything at all for chiropractic office visits, for x-ray evaluations, or a whole host of other services. And for the few codes that Medicare does cover, it pays less than Wellmark. That's in Appendix 2 at pages 1204 and 1259. There's simply no relationship between plaintiff's yardstick or spreadsheet and their liability claim. The district court rightly held that the spreadsheet does not track their liability claim. And in fact, over 50% of the claims in plaintiff's spreadsheet suffered no injury at all because they were already paid in full or associated with fully insured products.
This be resolved with more subclasses to group the doctors of chiropractic? Some are better off, some not?
I don't believe so, Your Honor. Sorting out which chiropractors would have been better off or worse off in a but-for world requires individualized evidence regarding that chiropractor's practice, which self-funded employers it serviced, and what those employers would have done.
To the unpublished Court of Appeals decision in Butts that my colleague to my right as a judge authored, but is that similar in that class certification was inappropriate because there were too many individual variables?
That's exactly right, Your Honor. And the plaintiffs in Butts had what they would probably call a simple yardstick or spreadsheet, which was to compare the prices charged to insured patients with the charges to uninsured patients. But the Court of Appeals rightly held that what a reasonable price would have been varies based on a whole variety of factors. With respect to the theory, the district court rightly held the plaintiffs are judicially estopped, and they don't really challenge that ruling. Even ignoring judicial estoppel, plaintiffs' new theory would still require individualized evidence and still result in winners and losers across the class. Even if you assume that in the but-for world, an employer could purchase a self-funded product from Wellmark but would have to pay chiropractors 90% of the commercial rate for MDs and DOs, that employer still has choices. Under ERISA, the employer could, seeing how much chiropractors would be, choose not to cover chiropractic care at all, and instead send its employees to board-certified osteopathic physicians, radiologists, and medical doctors. In that case, any chiropractors treating that employer's employees would be worse off. Second, the employer could simply purchase a fully insured product, in which case the district court found there would be no injury, and plaintiffs don't challenge that finding on appeal. And even if the employer chose to remain self-funded and cover chiropractic care, it could impose limitations on that care. For example, it could say that it would pay the first $50 a month of chiropractic care, and everything else is the patient's responsibility. And when a patient sees that it's going to cost more to go to the chiropractor than an MD or DO, most will probably go to an MD or DO. And even if they go to the chiropractor, that chiropractor will need to collect the bulk of charges directly from the patient, which will result in reduced collections, increased bad debt, and a whole host of other issues. So no matter what theory the plaintiffs attempt to pursue, the undisputed record evidence forecloses them from proving their class theory.
District court correctly apply judicial estoppel here?
The plaintiff's petition in paragraph 47 alleged that the administrative services agreement creates an express agency relationship between Wellmark and its self-funded customers. We, unsurprisingly, moved to dismiss under the single actor, single entity theory. In response, the plaintiffs argued that the initiating contract, combination, or conspiracy is the ASA itself, and that but for that agreement, there would be no contract between Wellmark and its customers, and John Deere and other self-fundeds would be about contracting with chiropractors directly. That's exactly what the district court relied on in denying the motion to dismiss. On page 4 of the opinion, which is page 270 of volume 1 of the appendix, the district court held that it is when self-funded employers contract with Wellmark to gain access to Wellmark's provider network and have Wellmark administer their self-funded plans that plaintiffs allege the horizontal price fixing occurs. On the next page, taken as true, plaintiffs are arguing that the alleged illegal activity occurs when Wellmark and the self-funded employers enter into their contracts, and thus before Wellmark acts as a self-funded employer's agent. The district court held that if plaintiffs would permit, in plaintiffs' but-for world, if Wellmark and self-funded employers would still have an administrative services agreement, it might well have granted the motion to dismiss. Instead, plaintiffs' theory was that it was illegal to contract with Wellmark at all for the access to the network, or, as it was on page 270, to have Wellmark administer the self-funded plan. Plaintiffs cannot identify any abuse of discretion in that decision at all. I also briefly wanted to address the Combs case, which plaintiffs cited in the reply brief. Combs was nothing like this case for at least 5 reasons. First, the defendant essentially conceded commonality with respect to markets, whether the conduct was anti-competitive, and whether it had violated the Iowa competition statute. All of that requires individualized evidence here.
Or the defendant conceded commonality, okay.
In Combs, there was no undisputed evidence, let alone district court findings, that broad swaths of the class benefited from the challenge conduct. In Combs, the plaintiff didn't have an atypical antitrust theory alleging that Microsoft's customers would become its competitors in a but-for world. The plaintiffs hadn't conceded that the reasonable price varies by class members, or that Microsoft's existing prices could be reasonable for some class members. And finally, unlike Combs, the district court here was not confronted with a battle of the experts or having to resolve conflicting evidence. In Combs, the plaintiffs presented a complex expert model that the district court found was capable of proving to each class injury to each class member. The plaintiffs didn't even attempt to do that here. They had no expert, they didn't take any depositions, they didn't cross-examine our expert. They simply copied and pasted the administrative record from ABAS minus a 10% damages haircut. The district court didn't discount that evidence. It did the exact opposite. The court held that taking all of plaintiffs' evidence at face value, giving them every benefit of the doubt, they still hadn't presented evidence capable of proving antitrust injury to all class members. Unless the court has further questions.
So they didn't have an expert to defend a model that would provide a common issue to recover on, right? So that distinguishes this case from Freeman versus GPC, where they did have a model and you didn't get a formula that could resolve the case in one group.
Freeman's also distinct because for a nuisance claim, the plaintiff can prove fact of nuisance and fact of harm by reference to a hypothetical normal person. And if one person proves that normal person would have had a nuisance, that proves it for all similarly situated class members. And there's no concept like that in antitrust law. Each plaintiff must prove injury based on their own circumstances, not whether a hypothetical normal person would have been injured. And certainly there was no evidence that anyone benefited from the pollution in Freeman.
We affirm the denial of class certification, then what happens? Are we going to just have a couple are the individual claims large enough to merit pursuing a recovery, or is this game over?
I believe any of the claims have merit. I recognize that's not a question for today. The original Mueller case was brought over a $17,000 billing dispute. I expect that there are some individual plaintiffs that have would allege damages in excess of that. Thank you, Your Honors. We would ask that the district court be affirmed in all respects.
Just addressing the agency issue briefly, there is a clause in the ASA, it's paragraph 10.9, that says nothing contained in this agreement and no action taken or omitted to be taken by account or Wellmark pursuant hereto shall be deemed to constitute account and Wellmark a partnership, an association, a joint venture, or any other entity whatsoever. So there is a disavowal of agency right there in that clause, and everybody signed it. So that's that. Now, let's get to your real point, Mr. Justice Waterman. The first case we did in this whole series way back in the 1979 was the healthcare equalization case in the federal court. We had 150 plaintiffs in that case, all right? That took 1 day apiece for all those depositions, and it was really an unworkable thing if you're talking about convenience of the court and the parties. In the asbestos tire worker cases, we filed 800 plaintiffs in the federal court, 100 apiece in eight cases. The court said, well, there's enough individually in there that we're going to make 800 separate cases in our docket, which gave them a new federal district judge, a new magistrate judge, and 3 new deputy clerks. But that meant that we had to depose or allow our clients, each one of the 800, to be deposed. That's a big problem. Now, what this class action avoids is that sort of nonsense, because the class action rules itself says you get a sample, but you can't depose them all. Now, we have what, 2,000? No, we have 2,700, they say. Some of them are dead now, but I can bet you, because the statute hasn't run on one of them since 2007, that most of those people will join. And you're going to have a case in the district court involving 2,700 plaintiffs. And how are you going to deal with that? Well, the district courts in Iowa have been dealing with that for years in the asbestos things. They pick a bellwether case or several representative cases, and they try those, and whatever the result is, everybody else settles out. That's how it's done.
How it's going to affect the court system. I'm concerned about the trial and the trial. You're talking about 2,700 separate cases. I'm a former trial judge. That looks daunting. Fortunately, it probably spread across the state. But when you're talking about mini trial within a mini trial, you're not getting any advantage, are you, if the defense is right that there is a problem with the trial and a trial?
Mini trial, because the issue I understand.
Concerned with it. But obviously, we're working from a district court order where a trial judge said, in her opinion, this would require trials and a trial. So if that were true, doesn't that water down your argument about many trials individually?
It would, if it were true, it would be a point, right? But it's not true, because what she's looking at is something that's not an element of a violation of the antitrust laws. You don't have to prove that there's the self-funded, and she says it stays self-funded. What's it going to do? Well, you don't know. It is going to negotiate somehow or other to pay their employees' bills.
The issue that you don't know what each of these self-fundeds are going to do, and a lot of them may do different things, and you're going to end up having a lot of individual issues about who's better off or who's worse off, and that's where the district court landed. Why is that wrong?
Because you're dealing with an issue outside of the elements of the case. The issue is, were they a member of that combination? Were they a member of that combination? Did they pay that price? And then was there a market price? I don't know where we're coming from as far as speculating what somebody might have done outside of it, where it's an individual. It's always, I mean, you look at Chattanooga Foundry, and they're trying to find a market, not an individual, what the market would have done.
You got a red light again. You can wrap up.
Thank you very much.
Case of Chicoine versus Wellmark is hereby submitted, and the court will recess for the morning.